right, this is case number 21-240861. This is raised check cashing versus Utica Hotel Group. The matter is before the court on removal from the general civil division. It looks like this matter started in the small claims division of this court. There's an application for default before the court. Your who do I have from raise check cashing, please? Anyone from raise check cashing? Anyone go to Utica Hotel Group?
Yeah, that's me. Jacqueline Philly.
Say your name again. I'm sorry.
Jacqueline Philly.
Are you an attorney?
No, I'm the general manager here.
All right, thank you. Gotcha. All right, all right. So have you spoken with someone from Raise Check Cashing today, ma'am?
No, I haven't.
All right. So I'm looking here. I see that Raise Check Cashing filed a complaint for regarding $814.30. They received a notification to be here at 10 o'clock, and I see that it's just that time. So I'm going to wait a few more minutes, and then I'll call you back on this one, and we'll see if the other side is here. Right, so just stand down. I'll be back with you shortly.
Okay, thanks.
All right. Now the court calls case number 21-240431. This is just one moment.
Because they was in order.
Right. I mean, this is.
The first one is 777. You have that one.
Yeah, now I got that.
Yeah.
That was it. All right. All right. This is case number 21-165-777. This is Mobile MRI Stamping LLC versus City of Detroit. The matter is before the court, set on for a hearing on today's date. Your appearance for a mobile MRI stamping, please.
Good morning, Your Honor. Danny Jajo appearing on behalf of plaintiff P80645.
All right, thank you, Mr. Jajo, and good morning to you, sir. For the City of Detroit, your appearance at this time, please.
Good morning, Your Honor. Sarah Doman, P79128 on behalf of defendant.
All right, thank you, Ms. Doman, and good morning to you as well. So I know that I adjourned this, and I have a note indicating that the parties might have reached some type of resolution in this matter. Somebody go ahead and update on this matter.
Yes, Your Honor. I received a settlement demand from plaintiff today that I am in the process of discussing with my client. I haven't been able to get a response just quite yet. I think if we were able to get a short adjournment, perhaps 30 days, we might be able to resolve this.
All right, counsel, Mr. DeJohn, you are of the same mind that you might be able to get this to conclusion?
That's correct. I have no objections to an adjournment.
All right, so I will go ahead at this time, given that the parties are engaged in meaningful discussions, I will go ahead and set the matter over for 30 days as a control date. Obviously, if you get it resolved, you can just send in some type of order to close it out. If not, this date will give you a date to come back in front of me, and that's going to be May 31st, 2021, and that's going to be at 9:30 a.m. That's the next action date, and I'll anticipate either an order from you or I'll see you on the next day.
Thank you, Your Honor.
Sorry, Judge, did you say you wanted us to submit an order of adjournment, or was that in reference to a dismissal if we do settle?
Thank you for your inquiry. The court finds good cause for granting the adjournment. No order is required of the parties. You'll receive a notification of a new court date. You're not required to appear on that date if you've reached a resolution and you've submitted something to notify me of that resolution. Otherwise, you would want to show up at that time and we'll proceed with the case.
Thank you, Your Honor.
All right, thank you. Good day to the two.
Thank you, Your Honor.
All right, this is case number 21-240431. This is Molly Howard versus Michigan Auto Recovery. The court previously sent this over on a 45-day schedule and then set the matter over for the opportunity, if the parties chose, to file motions in this matter. I have received defendant's motion for summary disposition regarding this matter. That matter was filed for on the 15th of March of 2022. Your appearance for the plaintiff, or do I have an attorney, or do I have Mounty Howard? If you want to Zoom, say something at this time.
It's just me, Your Honor, I couldn't afford an attorney. I couldn't get in touch with public service.
All right, thank you, Mr. Howard. Good morning to you, sir.
Hey, good morning, Your Honor. Thomas Stidham, P 56504, on behalf of the defendant, Michigan Auto Recovery Service Incorporated.
Thank you, Mr. Stenham, and good morning to you as well, sir. Mr. Howard, you received a copy of the motion that was filed regarding this matter, a motion for summary disposition. Is that correct, sir?
I received some paperwork from, I guess, the attorney.
And you understand that the paperwork that the attorney filed, that they're asking the court to dismiss this matter, as they say that there is not a genuine material dispute, and that as a matter of law, they believe that they're entitled to a judgment in this matter. You understand that that's what they're claiming, correct, sir?
Yes, I do understand. That's what they're claiming.
All right. So let me hear from Mr. Stidham regarding this matter, sir. Go right ahead on your argument, sir.
Very well, Your Honor. Thank you. As the motion states, Your Honor, this action had its genesis on April 5th, 2020, in which the plaintiff's vehicle was ordered impounded by the Detroit Police Department. Michigan Auto Recovery Service Incorporated is a long time, more than 38 years, according to the affidavit, towing services provider for the Detroit Police Department, located here in Detroit. It was dispatched to the scene at that time on, I believe it was an evening on April 5th. The plaintiff's vehicle was loaded and removed to defendant's storage yard. And the reason, according to the police, was there was no license plate, an improper plate. And that is reflected on the impound card, which is attached as Exhibit A to the motion. Significantly, when one looks at the impound card, Your Honor, we can clearly see that the officer did take some detail, or at least some time, to actually complete the card, even highlighted the coolant, whether or not the vehicle had coolant. I would just note that's on the first page. But significantly, for purposes of this motion, there's been no items of personal property that were identified on the impound card or otherwise tagged for evidence. And as I read the plaintiff's complaint, it certainly sounds in conversion. I think he alleges that, quote unquote, some items were stolen from the vehicle. And what Mars is asking this court is, even when one looks at the evidence that's been presented and inferences arising from that evidence, even in support of, in light most favorable to the plaintiff, as the court is obviously required to do, it still just does not support a claim for conversion. Plaintiff, and I think this is the real crux of it, Your Honor, plaintiff cannot establish that, quote unquote, some items, whatever those items were either in the vehicle on that specific date at the time of impound, or more importantly, Your Honor, that the defendant, Michigan Auto Recovery Service Incorporated, did something to steal those items. There's no proof in any way, shape, or form that Mars, or Michigan Auto Recovery, rather, Your Honor, converted those items. And obviously, if plaintiff lost something, obviously the defendant's empathetic with that. However, it's not borne, or ought to be borne, at the hands of Mars. when the plaintiff's complaint is simply conclusory allegations. And I understand it's just speculation by the plaintiff. I understand that plaintiff may allege that there were some other items in there, but whatever they are, there's no demonstrable proof that Michigan Auto Recovery converted those items. So for all those reasons, Your Honor, we're asking the court enter summary disposition pursuant to MCR 2116C10 in favor of Mars. Thank you.
Thank you, Counsel.
Can I object to?
Excuse me.
I'm sorry.
You heard the arguments that have been raised in this regard. You may now argue in response to that motion, sir. Go right ahead, sir.
Okay, Your Honor, to the fact that the paperwork that I received from their attorney was nothing of what he's speaking to you now. Only thing I received was a copy of, I guess, their attorney's generated statement from an officer. The inspection card, I guess that's what's called the inspection card that was done by the police, didn't say anything about any detailed things about my vehicle. All it said was intact. It was not like anything wasn't like recorded that this was in the car, or as you say, coolant was in the car. There's nothing in the paperwork that I received from their attorneys stating anything about any of what he's speaking of. I went to Mars. I requested video from the to show where my vehicle was there to see if it was tampered with. I was denied video several times. I've been up to Mars several times over the past couple of years since this happened. I did not remove the vehicle from their premises. I asked for them for video before I even moved my vehicle, because I checked my vehicle to make sure my things were in the vehicle, and they were not. I did not touch the vehicle. I walked right back into their office and tried to speak to someone. I tried to speak to the owner several times, and he had COVID probably 4 times every time I went to try to speak with him. I spoke with him once. He offered me car parts. Attorney called
Your
me.
Honor, I'm just going to object to anything that may have been in the interest of a settlement discussion or something like that. I don't think that's proper for the plaintiff to present it to the court.
I'll allow the argument to continue. Obviously, the court does not take into consideration any settlement attempts that the parties may have made, as that would bear no ultimate relevance to the court's determination on this motion.
Very well. Thank you, Your Honor.
You may continue with your argument, Mr. Howard. Mr. Howard, let me ask you a couple of questions, sir. So,
Yes, sir.
What is it that was missing from your vehicle, sir?
I gave Mars attorney a list.
Let me stop you for a moment. Let me ask you, what was missing from your vehicle? Let me stop you. Let me ask you, what was missing from your vehicle? Tell me.
My table, my wet saw, my impact gun, all these things were brand new in the box. My child's tablet. It was a few different tools on the receipt that I gave him that I just purchased from Harbor Freight. It was like $600 something. It was like 5 something tools, and my daughter's tablet was $89.
All right. And so let me ask you about the vehicle. So what was it parked? The plate was expired, or no plate on the vehicle? What was going on? Plate was in front.
No, the vehicle was parked in a ex-girlfriend's driveway. I was going to get the vehicle, and the thing with the police, she had my vehicle being towed.
Okay. And when was it that you had seen the vehicle before she had it towed?
That day it had shut down. That day I was moving my vehicles from her house. I had a few vehicles at her house, and that was shut down in the driveway. So I was like, I packed a lot of my tools and stuff in the truck, and I was leaving, and the vehicle the U-Car shut down in the end of the driveway. Yeah, I had left to go get my brother, who's a mechanic, to help me. And when I came back, the police was there, and it was a whole fiasco. And my truck got impounded. I didn't leave it there. Only reason I couldn't go get it the following day because they said the impound was not open. So I got it, I believe, that Monday.
And so you did remove the vehicle ultimately from the impound, correct?
Yes.
Got it. All right, anything else you want to tell me before I make a decision on this motion, sir?
Well, like I said, I did request video. I was denied video several times. As I look at the rule, the city impound rules, your car is supposed to be secured in under 24-hour surveillance until you come get your vehicle, because it's in the tow yard's possession at that time. And like I said, I was denied video several times. Till today, they cannot produce any video, and my vehicle was sitting right there at their front door. So.
All right, thank you, Mr. Howard. Mr. Stebbins, you get the last word on your motion, sir.
Yes, well, that's, Your Honor, I would just add again, this is the first time I've heard of a table, the wet saw. I did hear about the tablet, but again, there's no proof that Mars actually converted anything. And the notion that somehow Michigan Auto Recovery did not produce video. Number one, it wasn't requested to produce video as part of this lawsuit, not once, not one time ever. And secondly, it does have video, but the plaintiff's allegation is the vehicle was there for however long it was there. I don't believe it was that long, but there's nothing on, and I think Mr. Rigo in his attached affidavit, which is Exhibit B, addresses the surveillance video part of it. And he says that they watched the video, both himself and his manager, and they did not see anyone remove anything from the vehicle. So this notion that somehow Michigan Auto Recovery converted this property out of the car is just not supported by the evidence. Moreover, Your Honor, I do want to note something. Contrary to what the plaintiff says about the impound card, Exhibit A, the police officer actually did make quite a few details of the extent of the damage of the vehicle. He writes specifically under visible damage / remarks, old damage. Under personal property, which is, I think, what Mr. Rigo was alluding to in his affidavit, in his experience, they usually complete that portion of it if there's something notable in the vehicle. And again, there's just no, even viewing everything in the light most favorable to the plaintiff, there simply is not a genuine issue of material fact here. And for those reasons, Your Honor, again, I'm not going to reiterate everything I've already stated. We ask that the court grant summary disposition in favor of the defendant.
All right, the court has listened to the argument on the motion for summary disposition in this matter. So the nature of that argument under MCR 2.116C10 proposes to the court that when the evidence or any evidence submitted under this matter is viewed in the light most favorable to the plaintiff, if I take all of the inferences and point them in the direction to favor Mr. Howard in this matter, that still the ability to establish conversion or that property was taken from the vehicle would not be sustained by sufficient evidence to allow this case to go forward. That's the argument that is being raised in this matter. And I think that counsel in this artful argument before the court brings us very close to the court having to grant such a motion, except on this issue that the defendant sorry, that the plaintiff in this matter indicates that he's gone to the shop several times and made requests of the video, and counsel has indicated that there is in fact video surveillance and footage with regard to this vehicle, and that an affidavit shows that that video surveillance is of the nature that it does not suggest that there was anything that was untoward or that was done that was improper in relationship to anything that might have been owned by Mr. Howard. The challenge here is that it's kind of difficult for the court to have all of the evidence to view in a light most favorable to the plaintiff without having the plaintiff having an opportunity to review the video that is available. It's my impression, my thought in this, that the video, based on the arguments of counsel who is an officer before the court and has submitted an affidavit, that evidence is likely not to reveal anything that would be supportive to the plaintiff's case. But the plaintiff is entitled to review that video to determine whether or not there's anything on that video that might support his case.
Your Honor, may I just make a comment, Judge?
No, not yet. Not
Okay,
yet.
I'm sorry.
So in that regard, I will take the motion under advisement, and I'll review the motion for determination after the defendant has had an opportunity to review the surveillance footage as it relates to his automobile. And because the reality of it is that here's where the rubber meets the road here, is that the argument that is made here, the statements made by Mr. Howard in as a part of the arguments made herein, is that he left the vehicle at a girlfriend's house or some other person's home, and that somewhere before he was able to retrieve the vehicle, that law enforcement directed Morris to come and tow the vehicle. There's no indication of what happened or did not happen to that vehicle prior to Morris being there. And so the police documentation of the status of the vehicle is set forth in an impound vehicle report. And of course, that report has an area that says personal property. And it does not list or indicate anything as personal property on the document. And so the only thing that we would have is then the plaintiff's statement saying that he had something in the vehicle. The officers don't say that. But he may have had something in the vehicle. But we don't know what happened to that vehicle prior to that vehicle being towed. We don't know if anyone. All of that is speculative kind of stuff. So the issue then becomes his reliance upon he wants to see video. Well, he has a right to see the video. And if the video shows that somebody's taking something out of his car, then maybe he has a compelling case that survives. But if it doesn't show that, then I don't see how Mr. Howard's going to be able to patch this case together. And that's just giving a real frank assessment of what this case looks like, particularly when the court has to view it from the standpoint of a motion that has been filed, where I point to all of the possible evidence in favor of Mr. Howard. And even if I do that, except for the prospect that there is surveillance video that may show something, other than that, there's nothing that will sustain this case. So he has a right to review the video, and I'll take the motion under advisement and set it for a final decision after the defendant has had an opportunity to look at the surveillance video.
Well, Your Honor, if I may just add one thing, because I want to clarify something. I don't want the court to believe that I misrepresented something. Sure. What the Mr. Rigo's affidavit says is after the plaintiff made the allegation regarding the computer tablet, my manager and I reviewed the surveillance cameras throughout the storage yard, and they did not show anyone entering the vehicle or removing anything from it. What I want to highlight for the court is I do not know if the video still exists, because the surveillance system, I believe this one, and I'll find out obviously and file a supplemental whatever is required. The system usually only maintains the video for a certain period of time if no one has marked it. And in this instance, what I wanted to just highlight for the court is this occurred on April 5th of 2020. The plaintiff didn't file the lawsuit for over, I believe it was around 4 months later. So I don't know if the existence of the video, if it exists right now. And so I have to find that out from the court. And if the court wants, I can submit an affidavit or something else to that effect if it does not exist.
Yeah, you would need to do that, but importantly, they are notified that the defendant was making a claim that something was taken from his vehicle. That would likely initiate the importance of preserving such video. So I'll give you 2 weeks, 2 weeks to produce it or provide some affidavit in that regard. And then I'll have to make a decision if they've destroyed video, if they've eliminated the video, or if they've preserved it. That's an important consideration in this case. So the motion is taken under advisement. The video has to be submitted to Mr. Howard within the next 2 weeks, or an affidavit submitted to himself and the court. I'm going to set this over for
May 12th.
I'm sorry.
You said 2 weeks? On May 19th.
I'm going to set this over for May 19th, 2021, 2022, I'm sorry, at 9:45 a.m. for the court's ruling on the motion. That day will be the ruling on the motion. I've already heard everything I need to hear. I need to have Mr. Howard's take on what's on the video that is submitted to you. Right. So that's my order in this regard, and I will see both sides on May the 19th of this week.
Very well. Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Then the next action date.
I can leave now, Your Honor.
Yeah, you got the date to come back, right?
The 19th at 9:45.
9:45. There's to give you a copy of that video in the next within the next 14 days, sir.
Okay, thank you.
Thank you. All right, we're back on the record in 21-240-861. This is Raid Check Cashing versus Utica Hotel Group. Matter is before the court on the filing of a small claims action. It looks like there's also an affidavit for entry of a default in this matter. Do I have someone from Raised Check Cash? Have someone from Raised Check Cash, or the record should reflect the report. I do have someone from Utica Hotel Group, correct? Do I have the attorney on this?
No attorney, just operational managers from the hotel.
Gotcha. I'm looking for Michael Beach. Looks like his name is here. All right. It looks like to me then that regarding this matter, just 1 second. All right, this matter was set on for 10 o'clock a.m. Notification was sent to the plaintiff in this matter to appear for the hearing on today's date. Looks like the plaintiff has not appeared, although the court, looking at the order to appear, notes that the proper Zoom number is there, that the proper date and time is on the notice, and the notice was sent to Ray's check cashing at 13746 Gratiot. It appears that the plaintiff has not appeared in this matter. Their failure to appear means that this case will now be dismissed. The court will enter an order dismissing the case based on the failure of the plaintiff to appear in this matter. I do wish you well. Good day to you. What's your name again, Miss?
Jackie.
The sound is kind of cloudy, so say your name again. What's your name again?
It's Jackie.
Jackie. All right. The case is dismissed at this time. You get an order in the mail indicating that it is dismissed. All right. Good day to you. Good day to you.
Thank you too.
All right, the court now calls case number 22-178077. This is Discover Bank versus Catherine Hedger. That's Hedger. The matter is before the court on the filing of a general civil complaint. I do see that an answer was filed in February of 2. I'm also seeing a motion for summary disposition. Looks like that motion was filed this month of April. All right, your appearance for the plaintiff Discover Bank, please.
Yeah, good morning, Your Honor. William Sloan, P41487, appearing on behalf of plaintiff.
Thank you, counsel. Good morning to you. I'm looking now for Ms. Hedger. Please,
Good morning.
Good morning, Ms. Hedger. All right, so this appears to be an effort to collect as a result of the use of credit. And there's been a motion for summary disposition that's been filed in this matter. Ma'am, did you receive, Ms. Hedger, did you receive a copy of that motion?
Yes, I did.
And I'm looking, did you, you didn't file any written response to it, is that correct now?
I did file a response with solo suit.
With, I'm sorry, you filed a response with what, ma'am, said again?
Solo suit. I don't know. I did it on my own.
Oh, I got you. Now I saw your answer to the complaint, but you filed some type of response to that motion for summary disposition as well?
I just filed the one, I believe. I'm sorry.
Okay, got you. So counsel, I see that you filed your motion on, looks like the 19th, just recently.
Yeah, I don't have it in front of me, Judge, but whatever, yeah, I'm sure whatever date you're looking at is correct. Would be the date that would be in the court file.
So that's only been a few days ago.
Yeah, I'm sorry, Judge, to interrupt you. I think we may have filed it initially earlier, which obviously the court rules require a longer period for a dispositive motion than a regular motion, which is, I think, just 10 days or 9 days. But a dispositive motion, I think, is at least 4 weeks. But I'm wondering if they renoticed it. That's my only thought.
Okay. Yeah, sometimes under an order of discovery, I would allow for a shorter period, but I don't see where I issued a discovery order or issued an order limiting the amount of time that would be allowed on the motion.
And we wouldn't want to limit it. I mean, we want to follow the court rules on the time that she has to file. If it hasn't been filed timely, it should probably be rescheduled.
So what we're talking about, Ms. Hedger, you probably already picked up on it, is that you have a certain amount of time to respond to the written motion that was filed, and that time is not expired. And so I didn't want to delve into that motion without you having time to respond to it in writing if you wanted to, and or to be prepared to argue orally on that motion. So under the rules, I'm going to set a motion hearing date, and that's going to give you additional time to go over that document. And you know, I'm talking about that 21-page document that was filed. You understand, right?
Yes, I do. Thank you.
All right. So yeah, I'll go ahead and set a new date in regard to this, so to give you time to respond to the motion. As the parties talked about trying to get this resolved, I know it's a claim that sounds like $3,200, about $3,000.
I don't think we have, Your Honor. I'm open to, if Ms. Hedger would want to discuss it today, certainly we could do that.
Absolutely. Thank you.
Yeah, that makes sense to see if maybe you can talk about it a bit, because there's a lot of paper being filed and then found another answer. And if it's now the situation where it's quote unquote somebody else fraudulently used this card, then if it's something where maybe there was some credit used, you want to try to negotiate a way to resolve this, then maybe you can, there may be a chance to talk about that and figure it out. But let me put the two of you in a breakout room and take a chance to talk about it. Then come on back in and we'll figure out it.
Sounds good. Thank you, Your Honor.
Thank you very much.
Thank you. I'm looking at David Canine and Trevor Stratton, and I'm wondering why I'm seeing you. I don't have a file, so you'll tell me. All right.
I think we're wondering it too, Your Honor. Our case is up for today. The clerk did check in.
332, and it's noticed for pretrial, Your Honor.
Okay, somebody give me the case number, if you will.
It's 21-169-332. And I apologize to Your Honor. It's actually not, the pretrial box is not checked. The hearing box is checked. I don't know if that makes a difference or not.
Look up on, is it that reservation? No, should have been there.
Just one moment, gentlemen. My clerk has it on the list too, and I, for some reason, don't have it.
Okay, I just get you.
What's those last digits on it again?
332.
Oh, 332?
Mhm.
Yeah. I don't know why it's sitting over here.
Oh, you got it?
Yeah. So, it was in another group somewhere else. I do apologize. This is case number 21-169-332. This is Synchrony Bank versus Deborah Brown. The matter is before the court on the filing of a general civil complaint. The court has received defendant's answer regarding this matter as well. Your appearance for the plaintiff in this matter, please.
Good morning, Your Honor. David Canine, last name spelled C-A-N-I-N-E, P61828, appearing on behalf of the plaintiff. Thank you.
Thank you, Mr. Canine, and my apologies for the delay in this matter. Counsel for defendant in this matter, please, your appearance.
Yes, good morning, Your Honor. Trevor Stratton, P65124 on behalf of the defendant.
All right, thank you, Mr. Stratton, and again, my apologies. We kind of had you stuck in the corner somewhere, and I don't know if you got over side. And I saw two attorneys there. I'm saying, wait a minute, I don't have a file. All right, we're on the same page now. All right, so what's going on here? I do see answers and everything are filed up. Have you guys talked about this to see if there is some room? I'm seeing quantum merit recovery complaint. I don't get to see a bunch of those, but I also see account stated, so that all makes sense to me now. All right, so somebody update me on what's going on here, Mr. Canine.
We're close to settlement, Your Honor, but I think we would benefit from a period of discovery. We have a number of cases together at a very good rapport, and our success rate in terms of settlement is really good. So thank you.
That makes sense to you, Mr. Stratton?
Yes, it does, Your Honor. My client is working with a debt settlement company, and they're trying to get everything in order for my client. So when that happens, we'll be able to settle the case.
Got it. All right, makes sense. So I'll go ahead and set it on a 60-day calendar. I'll allow for a discovery over that period of time. You'll get an order from me, an order, a pretrial scheduling order that allows for 60 days discovery running through the next action date. That date that you'll be returning to the court is going to be June 29th, 2022. And that's going to be at 9:45 a.m. Discovery will be open through that date. Also, will in its order indicate that you may file motions and set them for hearing on that date of June 29th. Those motions can be dispositive or otherwise, as long as you allow the other side at least 10 days to respond to the motion. So if somewhere along the line you thought that bringing the issue before the court might help, you could file your motion, set it for hearing on the 29th. I'll hear it on that date, as long as you allow the other side at least 10 days to respond to the motion. So you'll get that, you'll get such an order from me, and then we'll set it for final pretrial conference on that date and addressing the issue at that time. All right. Anything further at this time, gentlemen?
Not from plaintiff. Thank you.
All right.
No, Your
Thank you,
Honor,
gentlemen.
sounds good.
All right, thank you. You'll receive an order in the next couple of days in the mail from me. Thank you. Good day to you.
Okay, likewise. Thank you. Bye-bye.
Thank you. Have a good day.
All right. Welcome back, counsel, and Ms. Hedger. Welcome back to the two of you.
Yes, Your Honor. I'm sorry to talk over you. We came to an agreement. So if I can place it on the record, defendant agrees to a consent judgment. The terms of the consent judgment is that she'll make 12 monthly payments of $175 per month, which totals $2,100. And as long as that's paid within 12 months of the date of entry of the judgment, that'll be accepted as settlement in full of the judgment amount, which is $3,021.49. So our office will send her the paperwork. Once we get it signed, we'll submit it to the court, and whatever date the court enters it will be the date that the 12 months begins.
All right. So in the interest of expediting things, Ms. Hedger, if counsel sends to me a consent judgment with your initial on it, and that judgment says $2,100 to be paid in 12 months, or with installments of $175 a month, and then that will be the end of this case. In fact, there will be an agreement to set the judgment aside and dismiss the case. If you sent something to me with your initial on it that says that, are you in agreement with that?
Yes, I am.
Yeah, Judge, just to be clear, the judgment amount is actually going to show the amount of $3,021.49, but the terms are going to indicate the defendant has agreed to pay it in $175 equal monthly payments. And if that amount is received, if the amount of $2,100 is received within 12 months of date of entry of judgment, plaintiff accepts that as settlement in full of the amount. So it's important for Ms. Hedger to know that if she doesn't pay it, then she's agreed to a judgment of $3,021.49.
Yes.
Of course, she would get credit for whatever payment she's made.
And so that's what would be on the judgment. In other words, you pay that $2,100, then about $1,000 of that judgment, $900 something of that judgment is eliminated, and then the case is over with as long as you pay that $2,100. That's your agreement?
Yes.
And you wouldn't have a problem with me going ahead and signing off on that with your initials on it. You'll put your initials on it. I'll sign off on it. Send a copy to you. You're ready to go. If for any reason you see something in that judgment that is different from what was talked about here, then use the Zoom number that you come on the Zoom. And when you come on the Zoom, just say, Judge, we agreed to this, but it says $5,000. I will get a hold of Mr. Salam, and we'll get back on the Zoom and we'll get everything correct. Right? And no tricks here is what I'm saying. You understand?
Thank you very much.
All right, very well. So
Thank you, Judge.
Submit the judgment. You can even do it via email. Let me give you that email address unless you already have it.
Yes.
LATIFAH Latifah Dot Hunter, last name is Hunter.
I'm sorry, Judge, I didn't catch the beginning of what you said. I'm sorry.
The first name is Latifah, Latifah. Dot. Last name is Hunter, at 36districtcourt.org.
Is that all spelled out 36 districtcourt.org?
That's correct, sir.
Okay, I will, of course, send Ms. Hedger the judgment for her to initial and send back to me. And she can email it to us as well, and then we can send it to the court.
Okay, whichever way you want to do it, just get it to me. And we'll,
Okay, thank you, Judge. Appreciate it.
Thank you.
Thank you, Ms. Hedger.
Thank you.
Everyone have a good day.
You too.
Thank you.
Bye.
She's all set, I think.